The statute of frauds avoids deceit by requiring that promises be in writing in order to be enforceable. But sometimes circumstances strongly indicate that an agreement exists, to the point where it seems unjust to allow a writing technicality to prevent its enforcement. In DK Arena v. EB Acquisitions 1, we'll explore whether the doctrine of promissory estoppel provided an exception to the statute of frauds in a real estate transaction. DK Arena, owned by celebrity boxing promoter Don King, agreed to sell its Florida property to EB Acquisitions. The parties entered into a contract in which EB agreed to purchase the property for $23 million and place an initial $1 million deposit in escrow. EB had 60 days to perform its due diligence, including conducting inspections it felt necessary, and could cancel the contract and have its deposit returned. However, EB had to notify DK of cancellations within that 60-day period, or else it agreed to accept the property as is. EB intended to use the property for a mixed-use commercial and residential development, which required government approval. Consequently, part of the written contract with DK required DK and Don King to participate in the approval process and participate in the project's marketing and promotion. The parties later met to discuss amending the agreement to include King as a partner in the development project. The parties met multiple times over several weeks to work out terms of a joint venture agreement as the end of the due diligence period approached, but no written agreement was reached. EB claimed that King orally agreed to a joint venture and to indefinitely hold in abeyance the due diligence period from the October 4th expiration date written in the contract, so they could work out the terms of the joint venture agreement. King claimed he only agreed to a 1-week extension and never agreed to the venture. When 1 week passed and EB didn't cancel the sale but failed to release the $1 million to DK, DK sued EB for breach of contract in the Palm Beach County Circuit Court. EB counterclaimed. The judge issued a judgment in favor of EB, finding that DK breached a joint venture agreement and that EB was entitled to its deposit under promissory estoppel. DK appealed to the Fourth Circuit, which affirmed the trial court's decision regarding promissory estoppel but reversed its finding of a joint venture. The Florida Supreme Court granted review.